Hello, I'm Javan Grant.
And I'm Scott Slater. One thing we often get asked is, in a rear-end collision, is the rear driver always at fault? Many people have heard that. The answer is not necessarily. It is true that in Florida there's a presumption that the rear driver is at fault. What that means is that the law assumes that the rear driver is the one at fault and that is going to be blamed for the accident. But that presumption or assumption can be overcome in a particular case by certain evidence.
And some of the things that you need to consider if you are in that situation, and some of the things the courts consider, is whether the rear-end collision was caused by, say, a mechanical failure, a brake failure, whether the lead driver stopped suddenly or swerved into a lane unexpectedly, causing the rear driver to hit the lead driver, and another circumstance is when the lead driver is actually parked or sitting in the roadway illegally. All of those things, in fact, surrounding those things, can lead to the presumption being thrown out, and where the question for the jury is, who was at fault, as opposed to the person who hit the rear end or the person who hit the lead driver being automatically assumed to be at fault.
So in the end, if you're involved in a rear-end collision and you've got questions about who's at fault, or if you have a claim, even if you were the rear driver, you need to consult with an attorney. Sometimes these cases aren't as simple as it's the rear driver who's at fault. So at Slater Grant, we're here to answer those questions. We handle rear-end collision cases all the time, and we're here when you need us.